The presiding judge ordered a trial within trial to assess the voluntariness of Nnamdi Kanu's 2015 confessional statements, following claims they were made under duress. Nnamdi Kanu's legal team contended that his written statements were coerced, citing lack of legal representation during interrogation and alleged threats by DSS agents. Nnamdi Kanu testified that he was denied access to his lawyer, threatened with loss of limited privileges, and physically assaulted, leading to a coerced confession. The prosecution denied any coercion, asserting that Nnamdi Kanu voluntarily provided the statements without any form of compulsion. Two DSS operatives, identified as Mr. CC and Mr. T, provided conflicting accounts regarding Nnamdi Kanu's interrogation, raising questions about the credibility of their testimonies. Discrepancies in the witnesses' statements led to concerns that they may have provided false testimony under oath. The judge emphasized the need to determine the truthfulness of the statements and the circumstances under which they were obtained before proceeding with the main trial. The courtroom drama sparked discussions about the integrity of the legal process and the treatment of individuals in custody. The outcome of the trial within trial will significantly influence the admissibility of key evidence in the main proceedings against Nnamdi Kanu. The court adjourned the session, scheduling further hearings to conclude the trial within trial and decide on the next steps in the main case. These developments underscore the complexities surrounding Nnamdi Kanu's trial and the importance of ensuring due process in legal proceedings. The courtroom at the Federal High Court in Abuja was charged with tension and anticipation on the morning of May 28, 2025, as the trial of Nnamdi Kanu, the leader of the indigenous people of Biafra, resumed. The case between the federal government of Nigeria and Nnamdi Kanu had already drawn intense public interest and media attention, though this particular proceeding was not televised or broadcast live, adding to the mystery and intrigue of what unfolded behind closed doors. At exactly 9:00 a.m., the session began with both the prosecution and defense teams formally announcing their appearances. Representing Nnamdi Kanu was Chief Mike Ozekhome, senior advocate of Nigeria, a seasoned legal mind who had been leading the defense team for several months. The prosecution team, representing the federal government, also confirmed their readiness to proceed with the day's scheduled activities. On the agenda was the cross-examination of the prosecution's third witness, a Department of State Services operative known under the courtroom pseudonym Mr. CCC. His testimony was critical to the case, as it concerned the circumstances surrounding the controversial confessional statements allegedly made by Nnamdi Kanu in 2015 during his first arrest. When called to the stand, Mr. CCC, who claimed to have worked with the Department of State Services for 27 years, took an oath before beginning his testimony. He confidently stated that he knew Nnamdi Kanu personally, identifying him as the leader and founder of the indigenous people of Biafra, a group which the Nigerian government had designated as a terrorist organization. He also referenced Radio Biafra, the station through which Nnamdi Kanu allegedly made inflammatory broadcasts that, according to Mr. CCC, incited violence and public unrest. Mr. CCC went on to describe his first encounter with Nnamdi Kanu in October 2015. He recounted that after Nnamdi Kanu's arrest, he, along with 3 other officers, conducted an interrogation. According to his version of events, Nnamdi Kanu was informed that the interrogation would be recorded and that he gave his consent. Mr. CCC stated that Nnamdi Kanu not only allowed the video recording, but also voluntarily wrote down a statement on the 23rd of October 2015. The prosecution then presented both the video interview and the handwritten statement to Mr. CCC for identification, and he confirmed that these were indeed the materials obtained during the interrogation. However, things took a dramatic turn when the defense team, led by Chief Mike Ozocombe, raised a serious objection. They argued that Nnamdi Kanu's statements were not made voluntarily and were, in fact, coerced. The defense informed the court that Nnamdi Kanu was denied access to his legal counsel during the interrogation process and was subjected to psychological pressure and physical abuse. The judge, visibly concerned by these allegations, questioned the defense. "Are you saying all three statements were made under duress?" Chief Mike Ozocombe responded affirmatively and emphasized the need for the court to examine whether the statements were truly voluntary. At this point, the judge made a pivotal decision. He ordered what is known in Nigerian legal parlance as a trial within trial. This is a legal procedure used to determine the admissibility of a confessional statement by investigating whether it was made voluntarily or under coercion. This mini-trial would run concurrently with the main trial, but would be strictly focused on the conditions under which Nnamdi Kanu's confessions were obtained. As the trial within trial commenced, Nnamdi Kanu was given an opportunity to provide his own account of what happened during the 2015 interrogation. Speaking solemnly and deliberately, he explained that he had requested to see his lawyer multiple times, but was repeatedly denied. He further revealed that the person who actually interrogated him was someone named Mr. Brown, not Mr. CCC, who was presently testifying. According to Nnamdi Kanu, he was kept in a dungeon-like cell and was only allowed 1 hour of fresh air each day. During the interrogation, Mr. Brown allegedly threatened that if he did not cooperate and write down what was dictated to him, even that limited hour of outdoor access would be taken away. Nnamdi Kanu described being physically assaulted and said he was bleeding from the nose when he eventually wrote the statement. He concluded that the statements he gave were not a reflection of his free will, but were instead the product of fear, intimidation, and physical suffering. The prosecution responded to these claims with firm denial. They insisted that there was no coercion involved and that Nnamdi Kanu willingly and happily made the statements. To support their position, they called their next witness, another Department of State Services operative known as Mr. T, designated in court records as Prosecution Witness 1. When Mr. T took the stand, he confirmed that he was present during Nnamdi Kanu's interrogation and reiterated that Nnamdi Kanu never made any requests for legal representation in his presence. Mr. T stated that the interrogation team included himself, Mr. James Brown, and a third agent named Mr. Collins. Curiously, he claimed not to know any individual simply named Mr. Brown, casting doubt on the identity of the interrogator described by Nnamdi Kanu. The prosecution asked Mr. T a series of questions aimed at dispelling the defense's claims. When asked whether Nnamdi Kanu appeared sick or asked for medical assistance, Mr. T responded that he was not a doctor and could not comment on Nnamdi Kanu's health status. He did say that bottled water was provided during the interrogation and claimed that Nnamdi Kanu did not appear to be under distress. One particularly tense moment came when Mr. T was asked whether he or any of the officers put words into Nnamdi Kanu's mouth or instructed him to write certain things about former Nigerian President Goodluck Jonathan. Mr. T categorically denied this accusation, stating that Nnamdi Kanu's statements were his own and were given voluntarily. The prosecution requested permission to play the video recording of the interrogation as evidence, but the judge, following proper legal procedure, declined at that moment. He reiterated that the trial within trial was still ongoing and that certain procedural stages had to be completed before such evidence could be reviewed. As the testimonies continued, it became evident that there were inconsistencies between the accounts provided by Mr. CCC and Mr. T. For example, while Mr. CCC insisted that Nnamdi Kanu did not request a lawyer, Mr. T was less definitive, saying he was unaware of any such request. This disparity raised concerns about the reliability and credibility of the prosecution's witnesses. The defense team capitalized on these discrepancies to reinforce their argument that Nnamdi Kanu's statements should not be admitted as evidence. The judge, taking note of the conflicting testimonies and the serious nature of the allegations, emphasized the need for a thorough examination of all facts before making a ruling on the admissibility of the confessional statements. He declared that the trial within trial would continue on subsequent dates, during which more witnesses may be called and additional evidence reviewed. Outside the courtroom, the developments sparked passionate debates among supporters and critics of Nnamdi Kanu. On social media and in various community forums, people discussed the implications of the trial within trial. Some saw it as a positive sign that the judiciary was committed to upholding due process and ensuring justice. Others viewed it as yet another chapter in what they described as a long history of political persecution and legal manipulation aimed at silencing dissenting voices, particularly from marginalized regions of the country. In a broader context, the case against Nnamdi Kanu and the issues raised during the trial within trial also reignited conversations about human rights, the rule of law, and the treatment of detainees by Nigerian security agencies. Critics pointed to previous instances where detainees were allegedly tortured or denied access to legal representation, emphasizing that these practices undermine the credibility of the justice system. The courtroom proceedings on May 28, 2025, also underscored the larger political and ethnic tensions that have shaped Nnamdi Kanu's case from the beginning. Supporters of the indigenous people of Biafra have long argued that their movement is not a terrorist organization, but a legitimate expression of the right to self-determination. They believe that Nnamdi Kanu is being targeted not because he committed any crime, but because he dared to challenge the authority of the Nigerian state and advocate for an independent Biafran nation. Many supporters viewed the inconsistencies in the testimony of the Department of State Services operatives as proof that the federal government was attempting to build its case on shaky and fabricated evidence. They expressed confidence that the truth would eventually come out and that Nnamdi Kanu would be vindicated. In contrast, critics of Nnamdi Kanu and the indigenous people of Biafra argue that the group's activities have incited violence and posed a threat to national security. They insist that the government has a duty to enforce the law and protect the sovereignty of Nigeria. From this perspective, the trial within trial is seen as a necessary but technical hurdle in the broader effort to bring a perceived agitator to justice. As the judge adjourned the session and scheduled further hearings for the trial within trial, the future of the case remained uncertain. The outcome of this mini-trial would have far-reaching consequences, not only for Nnamdi Kanu personally, but also for the legal and political landscape of Nigeria. The coming weeks will be crucial. If the court determines that Nnamdi Kanu's confessional statements were indeed made under duress, they may be ruled inadmissible, significantly weakening the prosecution's case. On the other hand, if the court finds the statements to be voluntary, they could become key pieces of evidence in the main trial. In the end, the drama that unfolded in the courtroom on May 28, 2025 was more than just a legal dispute. It was a reflection of deep-seated tensions within the Nigerian state, a contest between the power of the government and the resilience of a movement that refuses to be silenced. Whatever the outcome, one thing is certain. The trial of Nnamdi Kanu will continue to be one of the most closely watched legal battles in the country's history. And as the courtroom doors closed on that fateful day, the nation waited with bated breath for what would come next.
Hi, I'm your buddy, Dr. John Isebuhi. I want everyone to listen very well. Without the Igbos, Nigeria is going nowhere. If you have empirical evidence that is stronger or better than what I want to say, please present it. After the Civil War, I learned that each Igbo man was given 20 pounds. Now I want to ask you a question. When you go to Igbo land, is it 20 pounds worth of houses or architectural designs that you see there? So when you are against people, you need to ask yourself a question. Are these the people that can be defeated? Nigeria has set up a system, a systemic that works against tribes that they feel are not big enough, or tribes that can reinvent or bring a level of innovation to the ecosystem of the nation. And one of those tribes is the Igbo tribe. Why is Kanu still in jail? Because the system wants him to be in jail. Some people feel this guy, if we leave him, he's going to cost us the free money that we get from the system. Now that you have heard Kanu and you have heard Senior Ekpa, has insecurity abated? The answer is no. Now look at the last JAMB exam. A whole tribe, the 5 states, they said it was a computer glitch. Ask me which tribe will take that. I'm from Edo State, and if that had happened to Edo State, I will speak out. But as a child of God, anywhere there is injustice, it behoves on me to come out and speak the truth. Why will you just a whole tribe, you said to the computer glitch? Nigeria, this wickedness too much. What you guys have to understand is this: God is always on the side of the oppressed. And until Nigeria learn to integrate the Igbos, we are going nowhere. I have done statistics of all the black tribes in the world. Listen to me. If there is one tribe that would drive the revival or the economic revival of the black race, it is the Igbo man. Take them anywhere, they succeed. In the deepest of villages in Nigeria, they succeed. Does that not tell you something, that these are not people you should keep oppressing? Almost the youngest billionaires in Nigeria, they are Igbos. The richest tribe in Nigeria are the Igbos. I don't care what anybody say. I mean, the data is there. Most of the billionaires in other tribes, they are elders, 60s in their 70s. Look at Igbo, young boys, what they are doing. And we think we can just cut them off. We are making our journey to freedom very difficult. And I want to tell Nigeria, find a way to integrate the Igbos. I know the Igbos, they have their problems because they easily sell themselves. You give any of them money, some of them, they sell their brothers. But let me tell you, Igbos, if you know who you are, you will not bow. There is something unique about you guys. I doff my heart for you guys, because what you guys have passed through, you are still thriving. No tribe will pass through. Every tribe in Nigeria fight for positions. But they cut you guys out of political platforms. but yet you are able to reinvent yourself. If you know who you are, you know that God has given you the scepter to liberate the black man out of the quagmire of economic doctrine. Please, Igbo man, stop loving money and start loving yourself. Because what is in your hand is not in the hand of any tribe. I stand to be corrected. God bless.
Yes, good morning to you all, Biafrans. Greetings to everyone. Most especially, I want to take this opportunity to greet our able leader, Nnamdi Kanu, our Prime Minister, Mazi Simon Ekpa, Deputy Prime Minister, Dr. Madam Ngozi Arabweze. My allegiance goes to you all and the whole Biafrans and the 40 states of United States of Biafrans. I greet you all. Today, there is something that I want to bring to our table concerning our Prime Minister, Mazi Simon Ekpa, and the Finnish Authority. You see, many people have been speculating that Mazi Simon Ekpa, the Finnish Authority is going to jail him. The Finnish Authority has connived with Nigerian government to do what they know how to do best, corruption, and, shook hand with the president of Nigeria and the vice president, and all that pictures is flying everywhere, which I understand practically well. Now, I understand that there is no man that cannot sell out. I understand that these people are just animalistic in nature. They don't respect, most especially we, the dark skin color people. They really don't care. If the white people, some of them, if they are done with you, using you, they throw you to the trash. That is what they do. If they are done using you, they just discard you. They don't care about you. Now, but I want to still continue to stand on what I believe in. And Biafrans know this too well. Mazi Simon Ekpa can never be jailed. Mazi Simon Ekpa would win this case of Biafra and the Nigerian terrorist government. In court, he who accuses must come to prove Nigeria never wanted this case. Believe you me, this case is not all about Nigeria coming to, terms with Finland to jail our prime minister. It can never happen in this country. This country is not Nigeria. And I had this argument with somebody yesterday, and I was telling this person that, look, Finland may have connived. Finland may have sold out. Money might have changed hands. Our oil might have been negotiated by Nigeria and Finland. Keep Mazi Simon Ekpa away. But there is one thing that they forgot to tell me. Alexander Stone is the president of Finland. But Alexander Stone is not bigger than the laws of United Nations. Alexander Stone is not bigger than EU law. Alexander Stone, one man, is not bigger than Finland and can never be possible. Alexander Stone is still subjected to the rules of engagement and rules of the laws of the country. He cannot manipulate anything, whether they like. Let them bring evidences, let them bring whatever, which Nigeria has failed today to bring. So, whatever they are planning, if Alexander Stone likes, let him go to Nigeria and lie down with Tinubu on his bed. Let him go to Nigeria and embrace Tinubu. Let him go to wherever he wants to go to. The law remains sacrosanct. It doesn't change. I don't care to know what anybody talks about. So this is the things you people are going to be hearing. Oh, they have sold out. Yes, they have sold out. But I still do not believe in them. But one thing that I'm sure of, their law system. Somebody say, oh, they're going to be twisting the law. Oh, they're going to come this direction. They're going to go towards the other direction. And I'm saying, let us wait until that day comes. You see, one thing I have understudied in international law, you accuse the person, you must come to prove your case. The accuser must come here to defend his case. The prosecutor must come here and defend the case. If you say this guy has carried genocidal attacks, terrorist attacks, you must come to explain. One person must come here. And I want to reaffirm my word to Biafrans that this was never the plan of Nigerian government. The plan of Nigerian government is, number one, stop the redeclaration of the independent state of Biafra not to happen on the 2nd of December, which they failed. Secondly, bring back Simon Ekpa so that we can handle him and deal with him in our own way. These were their plan, and those two plans failed. And now, what are they standing on? Nothing. Up till today, they have not given us dates of the set court hearing. They have not given us dates of the set court hearing. Why? Because they have nothing against Simon, and I'm telling you the truth. So when people comes to bring this notion that, oh, Simon will be jailed, Simon, Nigeria has gotten bilateral agreement, it doesn't concern. If Alexander Stone, let him go to Kenya for more evidence. Do you know that if Alexander Stone's hand is in this illegal, removal of our prime minister, he must come and prove the reason why he did what he did to the prime minister. That is what I want you to understand. Alexander Stone can never be bigger than the laws of the United Nation. He can never be bigger than the laws of the EU. And I'm telling you, and Alexander Stone can never be bigger than the Finnish law. It can't be possible. Not on this planet Earth, I'm telling you. Go and check my word everywhere. Anywhere. Why is he suddenly traveling to Kenya? Why is he suddenly, trying to make some funny moves? I'm not shaking. I'm not scared. I've lived abroad so many years to understand what the laws of this land says. And I must give you some instances. Number one, there was this man called Omar Odiko. He was in the United Kingdom. And I made emphasis with some other things. Look, they came, despite the fact that UK are the one colonizing us or colonized us. Now, they came to kidnap this man, put him in a crate, and he was discovered at the airport. And UK quickly retrieved this man, put him back, and cut their relationship with Nigeria for 2 years, sanctioned Nigeria. I can't remember what the sanction was. Now, why did they do that? If they don't do that, UK people will not be, comfortable or confident enough to come to the UK. People will be looking at UK as a country that is not safe for any tourists to go. You understand what I mean? Now, when you talk about Cho Ayuba's case, Cho Ayuba is almost in the same critical condition with our prime minister. Cho Ayuba's case is still the same thing. Now, they are not able to convince Cho Ayuba. They are not able to put him away. Why? Because their system of law works for them. And the reason again is that Dr. Cho Ayuba's case, they have nothing against him. So there is no evidence to put him away. The only thing that they can do is to delay him. Because you cannot jail a man who is fighting for his own freedom. It is not done anywhere in the world. Now, our prime minister's case can linger for long, but you see, freedom is coming to us. Freedom is coming to us. So let people stop putting this fear in Biafrans, which I don't like. If I am not here, I am not going to be saying this. But I'm here, I'm on ground, I know what is happening. Again, I'm speaking in the direction of what I understand and what I know. I am not speaking for my government or Biafran government. I'm speaking in the direction of what I believe in, and I have seen it work. So all this, the prime minister is shaking hand. All this prime minister has got. They have gotten the prime minister, the Finnish government has. They have gotten bilateral. Let it stop. Let it stop. Let Nigeria come to Finland for the defense of their case. He who accuses must defend, must come to prove. That is what the law says here. So when you incite fear in our people, it doesn't make any sense. Please, let us stop this thing. It is not helping us. And I want to use this opportunity to tell Biafrans that our embassy is going, is coming up next tomorrow. The inauguration of our new embassy is coming up next tomorrow. in United States of America, Washington, D.C. In Washington, D.C. So if you are in America, please, I will encourage you to come and witness what this woman called Madam Orabueze, our Deputy Prime Minister, has been able to achieve in less than 6 months. So, more is to come, but this one will be the backbreaker of every country, and the opening of our embassy, the victory of our Prime Minister would immediately make the world to recognize the United States of Biafra. And I want to say this to Biafrans, that we are already gone. Nigeria can never defeat Biafra. It's not on this earth. Go and mark my word anyway. Can never and have never defeated us, if not from the Western power. That is the same thing that they went to do. But this time it will hook them. And it will hook them very bad. Believe you me. So please, this fear, let us stop it. It's not helping us. Alexander Stone, if he likes, let me tell you people one thing. The UK Prime Minister, former UK Prime Minister, if I remember his name now, was Boris Johnson. He resigned because there were so many allegations against him of some things that I wouldn't want to mention. And this man was not bigger than the law. He had to resign. Now, if Alexander Stone likes, let him go and be eating with Buhari. Let us be seeing Tinubu. Let us be seeing it. He doesn't move anybody. He who accuses me must come to the court to prove, because you have to respect my own human rights first, which was taken away from me, and then you subjected me to all manner of, intimidation, assault, and insult, and pains, and then you want me to walk away. So please, I want to use this opportunity to tell us, you don't know the laws. Please don't say they will twist it. Let us see it until that day. Let them come and twist the law and let us know. Because I cannot be re-educated, I cannot be miseducated in what I know. It is not possible. Until that final day. I don't trust these people, remember? I don't take their word for word. But when it has gotten this, do you know what is terrorism? Do you know what it is for somebody to call you a terrorist? Not a small case. So it is not a small case at all. Not be my case. Not be say, I see I'm with firearm. This one is a country is accusing you of terrorism. And that country that is accusing you must come to prove. Why don't you people get it? And then somebody is seated, they have sold out. Yes, I know they have sold out. But where would it end at last? Is it not the court? Why is people not coming to Nigeria today for any business? Because nobody trusts their judicial system. Anybody that come there to do business knows that if anything happens to their money, they don't have court system that can provide, that can protect their wealth for them. And then the collapse of the security and insecurity in the country is what the problem is. Nobody can come to Nigeria for all these foreign investors. They cannot come. Number one, there is insecurity. Number two, your judicial system is not working. There is no human right in Nigeria. These are the things they look at. And you think Finland will succumb to this pressure? We have USB, United States of Biafra, who is dealing with them, and another country is dealing with it, and the world is watching, and they will now say, cyber incitement to commit terrorism. Then boom, you are guilty. Akoko, you that what do you call you that said that Mazi Simon Ekpa has committed a crime must come. That is where they will draw Nigeria to the international world, and that is where Biafra will be discussed for the very first time. Thank you so much, Biafrans. I love you guys. Believe that we're winning this case. Nobody's mind should shake. Everybody are learned in their own way. I'm not to read, but go fit try me in that area. But I still go. You understand? But most of you are smarter, more intelligent than I do. But leave that to your intelligence. Leave this your technicality. Let us face the reality on ground. The reality is that not on this earth. Nigeria will win Biafran's case. It's not possible. Believe you me. It's not possible. The signs are there. Do you think Finland is not watching what is happening in Nigeria? Do you think they are dumb? We will find out in court. Thank you so much, Biafran, and may God bless you all. Again, may God bless Madam Ngozi Arabueze for what she's doing for Biafrans and for what you are doing for every one of us. Thank you so much, ma. And Biafrans, I will see you in the other room. Thank you.
This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.